Hello, everyone. We're just going to wait a minute and we'll give people a minute's grace. There's quite a few of you on already, but we'll just give you another minute and then we will get cracking. All right, that's got to be a minute. Right. Okay. Hello, everyone, and thank you for joining us today. It's great to see so many of you here. So clearly the disciplinary issues are something that most managers and businesses are potentially struggling with and want to handle well, but maybe don't always feel confident about it. So pleased to see you here for the next half an hour. For those of you that don't know, I am Liz Chiver, so I'm the Managing Director of Halliday's HR, and this is my colleague Lizzie Walsh. She's our HR business partner. Very brief summary about Halliday's HR. So we are a HR and training consultancy based in Stockport, but we help small businesses who don't have their own HR teams across the whole of the Northwest. A side note that we are recording today's webinar, so we will be sharing this with you afterwards, along with a copy of the slides. So don't feel like you need to, scribble everything down. We will be sending those out to you. And we can see you, well, some of you, but it's absolutely fine if you don't want to have your cameras on. There's no pressure whatsoever. Quite happy for you to have your brew, have your sandwich, whatever it is you brought for lunch today. That's fine, but we don't have your microphones on those. So if you do have any questions as we go through, then just pop those in the chat and we'll aim to answer those at the end. Okay, so over the next kind of 30 to 45 minutes, we want to make disciplinary processes feel much clearer, more manageable, and most importantly, much less daunting for you. So by the end of the session, hopefully you'll have a really solid understanding of when disciplinary action is appropriate, what your legal responsibilities of an employer in the UK are, how to run investigations and hearings fairly, how to apply outcomes consistently, and then we'll cover some of the common pitfalls, not fitfalls, that can lead to risk within the business. Okay. So, as we normally do, and as is our style, we'll keep everything practical and relatable. And like I said, if you've got any questions, pop them in the chat. But we will cover all questions at the end rather than as we go through the presentation. Okay, so when there's an issue at work, it's really important from the offset to determine what the root cause of that problem is. So it's all about having that conversation. So having the conversation with the individual to investigate the reasons as to why they're not doing something or why the behavior is a certain way before deciding which route to go down. So sometimes this can be a little bit confusing, actually. So just as a bit of a summary, conduct is what we call won't do. Okay, so this is a refusal to do something or an unwillingness to act. So basically, they're capable of doing it, but they are choosing not to do it. Okay, so in this scenario, you would follow your disciplinary procedure. Whereas capability, on the other hand, is can't do. Okay, so it's a willingness to do something, but not being able to do it. And in this scenario, you would follow your performance management procedure. And just a side note that if it is kind of absence and health related, that potentially if you've got an absence management procedure, you might use that to handle it slightly separately. But the reason why it's important to get that right from the beginning is that you can't chop and change between these processes and stack different warnings on top of each other. So if you get halfway down the wrong path before realizing, oh God, like we were going down capability and actually it's a conduct issue, you've got to start from scratch on the right procedure. So it just takes a lot of time and energy to have to kind of redo the work that you've already done. So, really concentrate on having those conversations and, speak to your HR team or us in terms of kind of, making sure you've got that right from the start. But obviously for today's purposes, we're going to be looking at conduct and that disciplinary procedure. So with conduct, you've got misconduct and you've got gross misconduct. So this is all about assessing the seriousness of the act of conduct or misconduct. Okay, so with misconduct, these are minor acts of misconduct, and they could be given a series of warnings before that potentially would lead to dismissal. And dismissal at that stage would be dismissal with notice. Whereas gross misconduct is a single act of misconduct that is so serious that it fundamentally breaches the employer-employee contractual relationship, and they could be summarily dismissed if this is proven. Okay, so this is what is dismissal with immediate effect, subject to a hearing, but without the need to pay notice. Okay, so if we think of this in kind of sporting terms, for those, those football fans out there, you could think of your misconduct as that yellow card, and whereas your gross misconduct is that red card. Okay. So just some examples we've got of misconduct then. And obviously this is just a handful that kind of we've picked out as being some of the more common ones. But the things like, poor timekeeping or lateness, those minor acts of negligence or carelessness. It might be unauthorized absence from work, or maybe not following the reporting procedure. It might be unreported minor health and safety incidents, failing to follow reasonable instructions, or perhaps kind of the offensive and insulting behavior or language, obviously on that kind of more minor scale, if you like, maybe kind of a bit of swearing or something like that. Okay. It is important to remember as I go through this that, it is your policy or rule that is relevant when you're assessing misconduct and gross misconduct. So rather than it being your subjective opinion as a manager or owner of the business or whatever, it's looking at your policy and seeing, okay, what is the case across the business, and making sure we're applying that consistently. So if you're not sure, have a check in your handbook. Okay. Just some examples of gross misconduct then. So we've got theft and fraud. We've got violent behavior. Now that's either actual or threatened. We've got discrimination, bullying, and harassment. We've got deliberately causing damage to company property. It might be being under the influence of drugs or alcohol, a serious breach of health and safety, working in competition with the company, and sleeping on duty. Okay. So we will cover more about this kind of legal framework and more about how you handle those, those disciplinaries and those misconducts and gross misconducts, and what the process would look like. But before we get to that bit, I just want to look at the legal framework. Okay. And I promise, and it's not all about a legal lecture. Nobody wants that on their lunch break. But it is about what you need to know to be able to stay compliant and to reduce that risk. So the core guidance is what's called the ACAS Code of Practice of Disciplinary and Grievance Procedures. Okay, so it by itself is not law, but employment tribunals do take it very seriously. So if you fail to follow it, then awards can be increased by up to 25%. Okay. So, and what it kind of talks about is it talks about your main obligations under that code from a disciplinary point of view. And these are basically that you act reasonably, that you investigate thoroughly, that you give written notice of the hearing and the allegations, that you share the evidence in advance, that you allow the employee to be accompanied, that you allow them to respond fully, and that you make a decision based on the evidence, not on assumptions. Okay. And, it's important that your disciplinary policy or procedure, that it follows this framework as an absolute bare minimum. So obviously it can of course be more than that. It can have more steps than that. It could be as complex as you want to make it, again, so long as you're happy to apply that consistently across the business. But this is just kind of detailing what those minimum kind of standards look like. Okay. It's probably worth noting here as well that it is vital that you communicate it to all of your employees. So, yes, you've probably got it in your handbook, but just making sure that then maybe, that you're reiterating that on a regular basis and drawing people's attention to it. And then making sure that you have trained your managers adequately as well in terms of what that process looks like, but also, to be able to manage it effectively and to make it, as efficient and effective as possible. I guess the very first step when we're looking at misconduct is that whole informal approach. Okay, so this is what we call the nip it in the bud stage. So the first step is to have just an informal conversation with someone. Okay, so this isn't about disciplinary at this stage. It's just about addressing concerns early in a respectful and private setting. But the aim is to really understand the context around the particular issue, to listen, to kind of encourage that, that two-way discussion before something escalates. So again, that whole nip it in the bud. It's important to explain what behavior is not acceptable. So, really being specific about it, gathering those examples so that you can make it factual, rather than those assumptions or those labels. It really helps to keep it objective rather than subjective. But it also, ensures that the employee really understands exactly what the concern is. It's also about looking at, what the impact is. So they get a feel for, why does that matter? Why is it important? What does it mean for the team? What does it mean for the company? And I guess the next part of it is about setting it up to be, okay, well, if this isn't great, what does good look like? What expectations are we setting for the standards of behavior going forward? And what changes do you expect to see? Okay, so, ideally, these conversations are best when they are, they're supportive and they're focused on that improvement, I guess, rather than feeling like, they've been hit with a stick. But, it's saying what you need to say and getting the outcome that you want, but just in that supportive way. Okay. You can, of course, make it very clear that if those improvements are not met, and the expectations are not reached, that potentially you're going to have to go onto a more formal disciplinary process further down the line. Okay. At the end of your kind of informal meeting, just you yourself, just make sure that you've kind of taken a few notes of the meeting. So just record, obviously who the employee was with, what you talked about, what the kind of concerns that were raised, the expectations, and then, ideally just follow it up in an email as well, just so that you've got that paper trail. And if things, do go formal, there's no risk of those kind of misunderstandings or disputes later on. Okay, so just moving on to the formal procedure then. So, if you've got your informal stage hasn't worked, you're potentially going to your formal procedure. The first part of that is all about the investigation stage. Okay. And as you can see from the slide, there's kind of numerous steps to that. So the first step would be to appoint an investigating officer. So the investigation, the disciplinary hearing, and the appeal should all be heard and carried out by different people wherever possible. Okay. And ideally of kind of higher seniority as you go up the chain there. Obviously, when you're working in a small business, it's not always feasible to do that, and that's absolutely fine. But if you are working within a bigger organization, then the expectation is that people will have different roles, and if you can consider this again up front, it makes it much easier to make sure you've got those different levels to go through if it does get to that. The second step is all about considering suspension. So you mainly would consider doing this with allegations of gross misconduct, okay? But it's where, somebody is accused, or where, it's obviously quite serious. Normally you would suspend someone if they were thought to maybe interfere with the investigation, or it could put the company at risk with them staying in the business while the investigation was taking place. So, maybe they had access to like financial records and there was potential sabotage or things like that. Then that's when, you would look to suspend. If you are suspending someone, then it is on full pay, okay, until the investigation is concluded, okay. It's important to reassure the employee that this is what we call a holding sanction. Okay, so there is no presumption of guilt at that moment in time, and it's not a disciplinary sanction or a prejudgment. It is just an opportunity to collect all of the facts, and whilst you're collecting all of the facts, doing the investigation, and doing that as quickly as possible as well. I think that, sometimes there's no set timescales in terms of how long somebody should be off, but obviously because they are being paid to be off, generally you will want to do this as quickly as possible to be able to get them back in the business. You will need to confirm suspension in a letter to them, just outlining everything that I've just said. And also, people will be expected to attend meetings and to, investigation meetings, that type of thing, whilst they are suspended. And they should not contact anyone else at work unless you authorize them to do so. Okay. Step 3 then is to carry out the investigation. So the investigation is that fact-finding process. Okay, so as I've just kind of said, the purpose is to gather the relevant information so that the investigating manager can fully understand what has happened to make a fair, informed decision. Okay, so at this stage, they're not reaching any conclusions or assigning blame. They are simply seeking clarity. Okay, so it's important that the investigation manager considers any evidence that supports the allegation or concern raised. And it might include like documents, emails, they might want to get witness statements, basically any information that might be relevant to the investigation and to the allegations. It's about assessing each piece of evidence, okay, objectively and without those assumptions. So, it's about not putting those assumptions and making sure that, you're looking at it from both sides, all of the angles, kind of actively testing the information from both, rather than having that kind of single narrative, because overall the goal is to establish kind of what we know to be factual based on the evidence. So, you really need to kind of separate that from opinion, assumption, and hearsay, and looking at what the physical evidence actually is, and what can kind of be reasonably substantiated as a result of that. Okay, then the final step in this process is that, once all the evidence has been reviewed, then the investigating manager can decide whether there is a disciplinary case to answer. So at this stage, like I've said, they're not determining guilt or kind of delivering any kind of outcome or saying, this is going to be a final written warning, it's going to be a written warning. They simply determine whether the matter should progress to a disciplinary hearing or not. Okay. So I'm now going to pass over to Lizzie, who's going to talk through this stage of the process and about the hearing.
Thanks, Liz. I know we said questions at the end, but I did just notice a message pop up. I think it was from Carly. Thank you. Just in terms of when somebody is on suspension and whether or not, if they do contact somebody, no, it's fine. So Carly, don't worry. Whether or not it can be used against them. And I guess it depends on maybe who they've contacted, what they've contacted them about, and what it is that they've said as to whether or not potentially that interferes in the investigation or not. So I couldn't say for definite yes it would or no it wouldn't. I think we would have to look at the circumstances at that time. So hopefully that answers that question. But yeah, thanks, Liz. So I guess when it comes to inviting an employee to a formal hearing, it's important to communicate clearly and professionally, whilst obviously keeping that kind of supportive tone. Yes, it's disciplinary and what we call a punitive measure, but at the end of the day, it is about them having a fair hearing. So the key points when sending a written invitation to somebody are to aim to provide at least 48 hours notice of the actual hearing date, to remind the employee that they have the right to be accompanied by a trade union representative or a workplace colleague of their choice, to outline the specific allegations being addressed. That helps to give transparency with the employee so that they obviously understand the purpose of the hearing and prevents that confusion. It's about being clear in the letter about the potential consequences that could arise from the hearing. So that ensures that they understand the seriousness of the matter while keeping the message factual and impartial. So like Liz said, what we're not saying is that this is what is going to happen, but it's the potential, as a result of your misconduct, this is the potential outcome of a disciplinary hearing. As part of that invite letter, you need to provide copies of any evidence that will be discussed at the hearing. So that gives the employee a fair opportunity to review and respond appropriately. It gives them that kind of advance notice. What you don't want in a disciplinary hearing is for any new evidence to be tabled, because that potentially is going to delay any adjournment or any decision making. Likewise, you may give the opportunity for the employee to provide a further written statement in advance of the hearing, if you wanted to do so. You need to be including the details of who will be chairing the hearing, so knowing who is going to be leading on that helps the employee to feel prepared and hopefully reassured about the process. And then the obvious, I guess, is finally confirming the date, the time and the location of the hearing. Just helps to avoid any misunderstandings and ensures that the employee can plan accordingly. Now, sometimes you may need to rearrange the hearing, perhaps if, trade unions can be very busy, if you need to rearrange it if the representative isn't able to attend. And we would say, it is probably reasonable to delay and rearrange once, maybe even twice, but anything thereafter is probably pushing it a little bit. The cynic in me might say that that's delay tactics kicking in, unless there are, of course, there's a legitimate reason for why it is that they are wanting to postpone it for a third time. However, there comes a point where if you are not getting a date in the diary, then so long as you advise them in advance in writing, you can go ahead in their absence, and then they would just simply get the outcome afterwards. So that is possible. Then, when we're in the actual hearing, then always ensure that it takes place in that private setting. It's about creating that safe space for the individual. It just helps to, respect confidentiality, helps the employee to hopefully feel that little bit more comfortable about speaking openly. So the chair should then start with brief introductions, so outlining the roles of everyone present, including the chair themselves, the HR representative if they're there, whether a note taker is there, and then the role of the representative as well. They then need to clearly expect the allegations that are being considered within the hearing. And then the actual hearing is about giving the employee a fair opportunity to present their case. So it's very much about listening actively, asking the relevant questions to make sure that, as the chair, ultimately they've got all the information they need to be able to make an informed decision. The employee themselves may well have explanations, that they should be considered. There may be what we call mitigating circumstances that they put forward that again need to be taken seriously and considered. And that helps to demonstrate that impartiality and the thoroughness to the process. Before then bringing the hearing to an end, it's always worthwhile just asking whether or not anybody else has anything else that they wish to add. It just helps to ensure that all the relevant information is heard there and then in the hearing before a decision is made. So the next step is to then adjourn the hearing to review the information and the evidence, and that allows time for that careful consideration before a decision is made. And a bit like the suspension, there is no time frame when it comes to how long that adjournment needs to be. At the end of the day, it just needs to be a time frame that allows for everything to be considered. Sometimes we see it's a couple of hours, sometimes it can be, a day or so. It just depends on where you're at with things. But once you've reviewed all the information, the chair then makes a decision. So it needs to be based on facts, evidence, and a fair assessment of what the employees said. In terms of confirming the decision, if you can, it's really helpful to confirm the decision verbally and then follow it up in writing. But if not, logistically, location or whatever, if that's not possible, then simply sending the outcome in writing is absolutely fine. You may want to then offer up a call just to kind of talk it through once they've had the letter and the opportunity to absorb it. But simply sending the letter in writing is also fine to do. And within that outcome letter, you do need to remind the employee of the right to appeal the decision if they feel that it's been unfair, and also how it is that they go about doing that and who it is they need to send that to. But in short, the hearing should be structured, it should be fair, it should be respectful, and it should ultimately give the employee the opportunity to be heard. Because the one thing that we need to make sure, if there is any potential risk, is that the employee has had a fair hearing. So doing all of that will ensure that that ticks all of those boxes there. So potential outcomes then of the hearing are, first up, it may well be a written warning. Now, granted, this is going through this flow chart is more so for your misconduct, because what we're saying is you get a written warning which stays on file for 6 months, and then any further instances of misconduct within that 6 months could then lead to a final which would stay on file for 12. Whereas actually with gross misconduct, like Liz said, you can go straight to the dismissal, or potentially you could even go straight to a final written warning dependent on the severity. But the process there is assuming that they've had a written warning, they misbehave, it goes to a final which then stays on file for 12 months, they misbehave again, and then dismissal is then considered, and that would usually be with notice. And Liz mentioned earlier about the summary dismissal notice, which is with no notice, and that's for cases of gross misconduct. Sometimes, as it says there, alternatives to dismissal can be considered. So sometimes you might have, a team leader perhaps that, instead of dismissing them, you may opt to remove them from the team leader duties and put them in more of a junior role. But you would obviously have to weigh up all of the pros and cons to doing that. But ultimately, when it comes to deciding on the outcome, consistency is absolutely key. So similar cases should lead to similar outcomes, even if the people themselves involved are very different. But it's about thinking about the seriousness of the misconduct, the employee's previous record, whether your policies are clear, what if any mitigating circumstances there are, and how you've handled similar situations in the past. And it is important to ensure that you document your reasoning fully. If you're able to explain clearly how you've reached the decision that you've had, then it is going to ultimately show that fairness. And it's remembering that, you're setting standards and you're protecting the company at the end of the day. So if we look at some of the most common pitfalls, then I can say that word, that cause problems during the process, and that could potentially land you in an employment tribunal, and they are all avoidable. So first up, we've got deciding the outcome before the process even starts. So yes, it's okay to have an idea. You may even have spoken to us, and we may even have advised. And yeah, do you know what? A written warning probably seems fair. But it's just about making sure that that in itself isn't communicated at any point prior to the hearing having taken place. Another one is inadequate investigation, or not interviewing key witnesses. Failing to share evidence with the employee in advance of the hearing. Skipping steps because the situation feels obvious. Using the same person for the investigation, hearing and appeal, although as Liz mentioned, unless it's absolutely necessary due to the size of your business, if you run out of people, it's fine to use the same people. Inconsistent punishments across different employees. So unless you can justify why similar cases were treated differently, that potentially might be a little bit of a sticking point. And overlooking health or disability factors, or that mitigation that may well have been mentioned that may need adjustments. But if you can avoid these, you will dramatically reduce any legal risk. Because if not, unfortunately, this is the scary slide, I'm afraid to say, it can get costly. So if an employee has been unfairly dismissed, you may be ordered to reinstate or re-engage the employee. This is an exceptional outcome, I'll be honest. We certainly don't hear of it very often, in all fairness. But a tribunal will look to award compensation, and this can be made up of a basic award, which depends on the employee's age, gross weekly pay and their length of service. So the maximum basic award for unfair dismissal claims is currently £21,570, and that increases every April. But after addressing the basic award, the often larger compensatory award will then be considered. And so the maximum amount that can be awarded for this compensation is £118,223 or 52 weeks pay, whichever is the greater. And again, that increases every April. We've then also got potential discrimination claims. So if an individual claims that they've been discriminated against as a result of having a protected characteristic, then they can seek to claim damages there. And this award is uncapped. So I couldn't even scare you with a figure, in all honesty, because it just depends on what it is that they're claiming they were discriminated against, and ultimately the impact that it's had on them as an individual. So it can certainly add up, in summary. So before we move into questions then, here is a quick checklist that you can take away. So ultimately, is disciplinary action appropriate? Actually, is it more so capability? Have you followed the ACAS code? Was the investigation genuinely fair? Was the hearing handled objectively? Is the outcome consistent and reasonable? And is everything documented? And if you can answer yes to those, you are certainly in a strong position. So thank you very much on that front. Liz, I've seen you've been typing away to some of the chat, but are there any other questions that we need to share with the group? And plus, if anyone has any other questions, please feel free to drop them in the chat.
I'll just cover off the question which Blair did ask, just in case anybody's not seen the chat. So Blair asked, is 6 months the legal time the written warning has to be on file, or is it at the company's discretion? So I replied and said, this is the ACAS guideline as a minimum. A company just can decide on longer periods should they wish, but so long as there is consistency of approach and written into your policy. So that's the answer to that there. I did actually just wanted to confirm that this that if someone has less than 2 years service and no protected characteristics, then potentially you can follow an abridged, shorter process than what we have identified here today. So potentially it's a much faster faster route to do that. But obviously that does require some support and HR advice. So if you think that might clarify, then obviously let us know. In terms of the Employment Rights Bill as well, in bringing the unfair dismissal right to making it a day one right rather than a 2-year right. We don't expect that to come in until 2027. So we've still got a bit of time where we can follow this abridged process for now. But it's still worth being really kind of watertight on your processes in the meantime.
Mm-hmm.
Was there another question?
Couple coming in. So Carly's asked, if the person being investigated complains their outcome is not consistent, can they claim because of that? Or if we could prove it was, do they have no grounds? So I think I don't know if you mean the investigation as such or actually the outcome of the hearing perhaps. So it might be that you issue a written warning to somebody, but actually the outcome, So it might be that you've issued a written warning to somebody, but actually, an informal warning to somebody, but actually in this instance, you want to issue a written warning. Again, without knowing the ins and outs of it, like I would say that, it probably would be okay. We would have to have a conversation around why it is that you were thinking to give a different outcome. But like you say, if you could prove it was, you were justified in your decision, then you would be fine to make that decision, essentially. Maria, are verbal warnings no longer provided or recorded, or is this essentially the informal approach and email follow-up? Yes, it is. So verbal warnings don't exist as such anymore. It is that informal stage, but we still say to follow it up in writing. And obviously, if the misconduct itself warrants going straight to the formal procedure, and doing your investigation and your hearing, then absolutely you can do that. You just need to make sure that, again, you're justified in why it is that you were doing that. But, that's why you've got HR, or that's why you can, speak to us in terms of if anybody's got a specific scenario that you're dealing with, we can have a chat about how to handle it. I was also going to say as well, if, in terms of disciplinary policy, if you don't have one, or if you think maybe it could do with a review, absolutely something we could help with. And when we mentioned about in terms of having different managers to do different stages, if you do end up running out of people because you might be a smaller business, we get involved in helping businesses. We can do the investigations, or, we can, with delegated authority, we can chair meetings. If you are running out of people, we can certainly support. You can just get in touch with us. And on that note, here's how. Doesn't appear that there are any other questions in the chat at the moment. So if not, thank you very much for joining us. As mentioned, we will send a copy of the slides and a recording to you. Thank you all. If there's no other questions, I'm going to boot you all out and end the meeting. Thank you all very much. Bye. Thanks, Holly. Bye.